Good evening, everyone. Good evening, everyone, and welcome to today's session. Warm greetings from World Law Alliance. I welcome all the panelists and the participants who are going to take part in today's session. The topic, as you know, is Employee Code of Conduct dealing with conflict of interest. A very exciting topic that is rarely discussed in sessions like this. And I'm sure there'll be a lot of takeaways for all of us. I'm joined by Mr. Yogen Vaidya and Mr. Manishi Pathak, besides other participants. And as a first step, I will be introducing these two gentlemen, after which I will give a very brief, just about 30-second introduction about World Law Alliance, who we are and what we do. And after that, Mr. Vaidya will take over as the moderator and we'll continue with our sessions. And we'll have about 15 minutes in the end for the question answers. So those of you listening in, if you have any questions, I'll really appreciate if you can send it either through the Q&A tab or through the chat option. You also have the option of raising your hand. All right, so Mr. Yogen Vaidya, that's the first introduction. He's the moderator for today's session and he will lead the discussion. Mr. Vaidya is a partner at EY Forensic and Integrity Services. He's gathered around 22 years of professional experience, out of which more than 14 years includes experience in providing businesses with fraud and investigative services. His area of focus includes dispute advisory and litigation support related services. He has led engagements involving fraud risk management, fraud investigations, financial statement, fraud, anti-bribery compliance, and dispute resolution. Mr. Vaidya's experience in these areas is spread across various industries, including real estate, shipping, oil and gas, pharmaceutical, infrastructure, agrochemical, and power sector. So welcome, Mr. Vaidya, to today's session. Now, about Mr. Manishi Pathak. Manishi Pathak has recently founded Unhad Law and has over 29 years of experience and has been advising foreign multinationals and major Indian corporates on company law, labor and employment law, M&A, that is mergers and acquisitions, and general regulatory matters. Mr. Pathak is also a prolific writer and has authored several publications. Now that brings me to who we are at the World Law Alliance and what we do. So World Law Alliance is an integrated global law practice and service delivery platform, serving excellence through the collaborative innovation of our members around the world. We currently have members in 50 countries with our headquarters in New Delhi, India, and our service offices spread across the world. With this brief introduction of the participants and about WLA, may I now invite Mr. Vaidya to take the session forward. Thank you.
Thank you. Aditi, can you put up the presentation, please? Am I audible?
Yes, you are, sir.
Thank you. I thank World Law Alliance, Federation of Integrated Conflict Management, FICM, for giving me this opportunity to talk on one of my favorite topics, that is Employee Code of Conduct, and more specifically about employee conflict of interest. So I've been doing significant investigations in white-collar crime and corporate frauds over the years, and have seen recently significant increase, specifically in employee conflict of interest. And this topic, as we are going to talk about in detail, is very, very wide topic, and we'll go into the specific aspects, what all things are covered, etc. During this session, we'll also deal with important facets on various aspects of conflict of interest. Specifically, if we look at the whistleblowing complaints recently, and in last 7 to 10 years, I would say almost like 50 to 60% of the complaints under the whistleblowing are around conflict of interest. And there are a variety of complaints I'm talking about. Financial relationship with vendors, third parties, deploying family members at third parties, vendor favoritism, kickback, sharing confidential information, information about the company, and corruption at workplace. That is a term typically people use, and various related matters are getting covered in the conflict of interest. It's not only about a financial transaction with a vendor or having some proximity with vendor, etc., but it is very, very wide. And as I said, almost 50 to 60% of the complaints pertain to this topic. As we all know, several corporates have done tremendous amount of work in putting together a framework by way of code of conduct, which is very, very robust, which is displayed on the websites, etc., and giving specific examples in certain cases about conflict of interest, what are those conditions, what are those situations, etc. However, what is really required further in terms of creating awareness, creating training programs, because most of the times when we do investigation, and at the end, as part of the natural justice process, we always have interaction with the subject. And typically, more often than not, people will say that they are not aware about the conflict of interest provisions or code of conduct, and they try and get away saying that we are absolutely not aware about stuff like that. So I'm going to talk about this in little detail and cover the key aspects of conflict of interest, which to begin with, I'll also share some of the global recent news on conflict of interest, which will give an idea and variety of what kind of issues we are talking about. What is conflict of interest? Little bit theory with some practical examples. What are the type of conflicts we are talking about? How typically it is occurring? And typical ways of avoiding such conflicts. What are the best practices in order to make declarations? How do you handle really the whole thing around conflict of interest? How the redressal mechanism really work whenever such conflict of interest is identified, etc. And then I will move over to my fellow panelist, Manishi, and we'll also go into the legal and compliance related aspects of conflict of interest. So with that, let me begin the topic. Aditi, can we go to the next slide? Yeah, thank you. So as I said, let me give some examples of from the global and the local world, which will give you a good indication about what kind of conflict of interest we are talking about. So to begin with, the first one deals with the typical, collusion. Wherever there is a collusion, there is a sharing of confidential information. There is a favoritism which is provided to any vendors, third parties, customers, any other stakeholders for that matter. And there is a activity, either it is performed or an act in defense of the company is not carried out, which is typically from a legal parlance called as omission of safeguarding of the interest, and which actually results into prejudicial interest of against the organization. That is where typically a conflict of interest. An example, if you really look at, this is a typical case of a personal conflict of interest where there are financial transactions which happen along with any vendor or any customer, and that disclosure was never made, or there are personal proximity in terms of some deployment of, let's say, a family member, etc., with any vendor, third party, or business associate, and that was never disclosed, and ultimately there is a conflict of interest. Third thing, again, from a typical participation in any vendor cartelization, or in the case of a bid rigging, where you don't disclose the interest in various entities, whether there is a minority shareholding, whether there is a majority shareholding, and specifically IRDAI came out with regulations on this for declaration of conflict of interest. Again, this is not very, very specific, or it is very, very common. We hear stories around cartelization, etc., which originates from conflict of interest, where even people participated in multilateral agencies, tenders, or large infrastructure projects, etc., and they don't declare that there has been some proximity in terms of any relationship whether financial or otherwise, and they end up landing up in violation of conflict of interest. And subsequently, either through the intervention by court, there has been declarations that there was a conflict of interest, and such award of contracts was cancelled subsequently. Typically, again, if you look at it in a different way, whether it is real estate, there are some specific regulations which is created over here, or even in case where a typical banking agency or any other players who is also dealing with the client's funds, and there is a requirement to handle these funds separately, but sometimes either due to any sort of condition or sort of getting into your by typical events where people mishandle or don't create that sort of a Chinese wall between clients' funds and own funds. And that's where, again, the conflict of interest arises. So there are several cases where either because of multiple, sort of transaction which is being entered with any third parties, there is a proximity which is kind of developed, there is a cushioning which is developed, and popularly, as we call it, there is no free coffee or tea in this world. So the slippery slope starts whenever an employee is kind of having any sort of comfortable discussion or off the record discussion, even if it is kind of customary for that matter. Let's say in any particular territory, that particular event or an activity may be a customary thing, but that can begin the whole slippery slope of from a conflict of interest perspective. So Aditi, let's move to the next slide. So here a little bit, couple of aspects I will just talk about. Whenever there is an activity which is against or prejudicial to the interest of the company, that will get clearly classified as conflict of interest. Now you can imagine that this topic is so wide that everything and anything which gets classified as prejudicial to the interest of the company, whether sharing of confidential information, whether the passing on internal information about estimate, whether favoring somebody by way of internal information, or waiver of any particular credit note, anything, for instance, with procurement or any sales where some specialized incentives has been passed on to any customers, to any business associates. From a procurement perspective, if there is any information which will help the supplier or a vendor, by which there could be exploitation of the transaction and which may lead to loss to the company, will be classified as conflict of interest. Again, very interestingly, people typically look at the conflict of interest as only one type of a thing. But if you really go into the details, there are multiple type of conflict of interest, and I would like to spend a couple of minutes on that, because it is very, very important. Because most of the time when we deal with investigative matters, people only look at actual conflict of interest. But equally at the same time, it is very important to also talk about the potential and perceived conflict of interest. And I'll spend a couple of minutes on that. Aditi, can we go to the next slide? Right. So obviously, people would be very, very familiar with actual conflict of interest, where, as I said earlier, any potential act by an employee which is resulting into any activity which is adverse or prejudicial to the interest of the company. And here I've given specifically one example, that hiring an unqualified relative to render services for your company, and whether you place it under direct payroll or indirect payroll, and then later on, sort of justify that, that is clearly perceived as a direct conflict of interest. What is potential here is very, very, again, very important. So it is very important to even, classify that as part of the code of conduct, where sometimes I've seen some of the code of conduct does not talk about the potential and the perceived conflict of interest. And that's where some of the employees may take an advantage. Hey, look, and they argue, in fact. And in fact, today also we did a matter where the guy was arguing that, look, potential conflict of interest, you have not included in the code of conduct, and hence you cannot ask me any questions about that. But even if in a situation where the actual business has not transacted or not taken place, but the very fact that that guy has made a registration as a potential vendor, right? Even the business was not allocated, and that person happens to be your relative or distant relative or a close friend, and in today's day, social media and other things where you can easily find out the proximity and the past business correlation or the relationship. And even the potential conflict like that can create great issues. And typically, when you speak about the senior management or senior employees, KMPs, etc., the yardstick or sort of the parameters or measurement or the tolerance level will become thinner and thinner at the senior level. And that's where even the potential conflict of interest will be very, very relevant and will be looked at it with a very, very detailed eye. Similarly, perceived conflict of interest, even if, let's say, somebody has acted absolutely at arm's length in any particular transaction, however, he has failed to disclose his relationship in any entities, whether it is business associate, vendors, customers, third parties, even in a situation of a bank of financing an industrial unit, etc. But there was some sort of past relationship and which was not disclosed. Even if the person has acted in his utmost capacity in arm's length, however, that particular situation can be also opened and questioned from a perceived conflict of interest perspective. So an individual typically and technically should always evaluate and abstain from participating in such transaction, as we always guide and provide consultation, that in similar situation, let's say if that business is very, very important for the company, the most ideal thing is to make the declaration of the conflict and then abstain from participating and being any sort of coming in the chain of command, whether even accepting quotations or processing quotations or even approving some of those quotations or being there in any level for that matter. So even potential and perceived conflict of interest are equally important. So whenever a person is looking at any potential violation or a declaration, it is very important to look at even potential and perceived conflict of interest. Let me move to the next slide, Aditi. I think this is very, very interesting and important that we lay down the foundation, what type of typical conflict of interest we are talking about. So let's go in some of the details. And most of the times when we do investigations and typically like the interview discussion, which happens typically at the end of any sort of investigation, we come across various situations where people say, hey, look, what is the harm? What is the harm in taking help of a vendor in booking tickets? What is the harm in taking help? I was not getting any other facility. I was not getting any other travel agency. I'm new to the city. But if you do a Google search, you will find hundreds of people who is ready to serve you. Why to go out and take that help from an extended third party, even if it is customer or a vendor? So any potential, let me start with personal financial investment, whether direct or indirect, active or sleeping. It is just a sleeping investment and I don't play any major role. People do argue on various matters like that, but clearly that will get classified as a conflict of interest, whether you do it in your name or in wife's name. Sometimes people are very smart. They say that, look, I'm not doing it. My family members are doing it. My wife is doing it. I have no role to play. But when you go into the details, you will see that only the name of the wife is used and practically the person is actually executing all this transaction and providing help on a regular basis. Similarly, if you look at serving any other potential organization, whether they are competing with the particular business you are into or not, but even if they are into another business, but that may also have an issue from a conflict of interest perspective, as in that there could be issues from a timing perspective, that you are not spending adequate time, which is again will be classified as prejudicial to the interest of the organization. Again, personal relationship, for instance, people may argue that, hey, look, attending weddings or attending birthday parties by vendors, third parties, is there any harm? It's actually human to attend such parties. Yeah, there is no harm. But so far as that relationship is restricting to professional means and there are invitation to others in the same horizontal level, then it is fine. Again, there are no exchange of gifts, etc. Because as I said, it's a slippery slope, and once it starts the coziness or the proximity, then where it ends, you never know. Similarly, any material interest of the employee or director in the relatives business, where the relatives are being deployed at customers or suppliers, and that particular part we find even exchange of emails taking place where the declaration has not happened. And people argue that, hey, look, that guy is actually not in seat of in a driving seat or not having any authority. But it's all about suspicion, the way, as an investigator or a lawyer will look at it when we are doing any corporate investigation. And that's where the problem typically starts. Similarly, even NGO for that matter, or any CSR initiative, let's say when an employee is participating in. But again, if there are any discretionary authority in that NGO, etc., and your association with that NGO is not declared, and your company has actually provided donation or participating in some activities where you would have introduced that NGO, but you did not declare that sort of a thing, again, there will be, some issues. Again, various things, as I gave example of a silly thing on sponsoring of a vacation, even if the payment is made for that sort of vacation, but taking that help of identifying a house or booking a ticket, even if it is a small railway ticket or a flight booking or any other guest house booking, anything, because as we call it, there is no free tea or free coffee in this world. Always any vendor or a third party, whenever they are offering such things, they are always trying to recover in some way or the other, whether with your knowledge or without your knowledge. Because once it starts and there is no materiality in terms of fraud or any non-compliance to code of conduct, even 5 rupee, like I gave example earlier, when it comes to a senior management and the KMP, even small issue, there is no tolerance, and people may have lost their jobs, and there are stricter penalties and other actions which is taken, where even small thing at that level has really transpired into non-compliances. So these are the various examples I thought will be very, very relevant to understand this topic of conflict of interest. And let's move on, Aditi. So again, very interestingly, just to simplify this topic absolutely for everyone's understanding, there are 3 questions which are very, very in every program wherever there are, we conduct on to do the training on conflict of interest. We make it very simple to say that, hey, look, if anywhere you have a doubt, you should always consult rather than rationalizing in your mind. And rationalization is key. Again, people who are familiar with the forensic or fraud triangle will say that wherever there are incentives and pressures, opportunities, and third thing, which is rationalization, wherever there are these 3 elements coming together, definitely there will be a fraud. And you can put this in any situation you want, any public domain fraud which would have occurred, and you will see this is the reality. Same way, if there are any rationalization which you are doing without consulting the HR, without consulting legal, without really understanding where it will, go into the non-compliances or glitches like that, typically you ask questions and consult. And 3 things, as I said, very, very important. Is there anything in your personal or working relationship that could be considered a conflict of interest? So it's like a mirror image where you're asking this question to yourself, that by entering into any causal relationship with a vendor or a third party or a customer, will it be open for any questioning? Will it have any element, even if it is perceived or potential, which can go against you? Can my relationship with a third party outside my workplace result in a conflict? Yes, most of the time, wherever it is parties, birthdays, etc., or even attending any other thing, attending weekend parties, having any sort of interaction or proximity on social media or other thing, are in today's date where the governance is becoming tighter and tighter. Independent directors, audit committee are becoming stricter, and the regulations with SEBI are becoming stricter. And there is so much information people want to talk about, and people want to blow whistle left, right, and center, and nothing is hidden for that matter, right? Everything is coming into light. In that sense, you have to be very, very careful in having any sort of side conversation or relationship with any third parties. Otherwise, the conflict of interest clearly will be out there. Again, the last thing is, can a personal interest or relationship have an influence on my duties and obligation? Always people argue on this. Hey, look, I may have a relationship, I may not have disclosed, I understand, but it has not resulted into a loss to my company, and I can prove it. But we are not judge, we are not God. Everything is not cannot be proved in black and white form, because suspicion is the big thing in today's time, where a lot of things are really cannot be proved. But once that breach of trust typically happens, or the relationship, goes away because of certain activities where you have forgot to, declare the interest in many entities as such, and there are some side conversation which has happened, and which is, throwing things in air about your relationship. And typically, if you belong to that KMP and senior management, then typically the things will start, having issues about. So typically, like we always guide, corporates, that these are the 5 things we should always try and follow to avoid any sort of conflict of interest. And if there is anything, please have a consultation with the right person, rather than acting in our own world, rather than rationalizing it. Always it is better to abstain from participating in that particular transaction, in staying away, in making a declaration, not only on oral basis, but also formally documenting that conversation with the immediate superior, with a copy to, head of HR or someone as senior in the organization, like that. So let me move to the next slide. So this is very, very important. Again, we thought it will be very relevant from a best practices standpoint in a conflict of interest situation, where clearly, as this is our experience, and again, I'm saying that typically people say that, look, I was not aware. My colleague is also having conflicts. He did not declare. He's into insurance business. He's into, sort of that multi-level marketing. Nobody told him. How many people are aware about it? Yeah, my boss knows it. In department, everybody knows it. So that's, kind of give a picture that everything is acceptable. So that's where the tone at the top, the whole overall compliance culture within the organization comes into play, where what is written in the document by way of code of conduct is really practically it is implemented, and people are breathing the same tenacity, the same density of the code of conduct, the conflict of interest part. So that's where, continuously the communication from the top by way of micro videos, or communication by way of letters, in any, sort of events, etc. I've seen at least people, large companies, following first 5 minutes or 10 minutes, they will talk only on ethics. They, hey, look, let's just do a refresh of our ethics, our code of conduct. These are the 5 things which is not permissible. There will be stricter penalties and stuff like that. Clearly, again, the framework around the conflict of interest, the code of conduct has to be very, very clear, with examples what is allowed, not allowed, so that there is nothing which is left to the ambiguity or left to the people to, kind of rationalize, as I said earlier. And time and again, there are videos which are circulated. Let's say even town halls are carried out after large investigation take place. And then without specifically naming people, I've seen at least corporates doing sort of at least case studies and showing that, hey, look, these are the 5 cases we picked up in the last 6 months. And this behavior is clearly not acceptable. Unless this is done, corporate will not have ability to, reprimand any employee, because whatever adequacy, from an adequacy standpoint, training and awareness is required to be done, that was never carried out. And hence, then you cannot expect people to really follow those regulations. Similarly, I think what is really working as a deterrent is the annual declaration process. And obviously, the code of conduct signature, definitely now I think I've seen most of the corporates following it. But at least people in high critical and sensitive areas like procurement, strategic sourcing, on sales side, wherever there are large decision making take place, and where there could be things which may go against the organization, even people in finance department, it is not out of place to carry out specific conflict of interest declaration process in those specific functions, at least let's say once in a quarter or once in 6 months for sure. So there should be some more additional checks and balance in such high risk probable areas. Again, as I say, training and awareness plays a major role, because probably, let's say if I talk about Bangladesh, probably everyone would be having a parallel employment, more at least large ones, I would say, because that's the culture in probably that sort of geography. But again, if we look at some areas, even in India, there may be some peculiarities like that. So that's where, again, organization will have to spend more time educating people. Hey, look, this is not allowed. That's insurance and any other thing, like I mentioned. Similarly, there should be a strong reporting mechanism, whether it is whistleblower mechanism. There should be continuous feedback which comes back. Otherwise, it's not going to work. So So multiple ways we'll have to deploy in order to do the right thing and set up the right framework from a conflict of interest perspective. Aditya, let's move on. This will be my last slide, and then we'll move on the legal and compliance aspect. So very clearly, again, we spoke about the proactive or the proactive pieces more from a conflict of interest and things around it. It is equally important that whenever, let's say, some event happens, let's say by way of a whistleblower letter, where people would have identified some conflict of interest and behavior on particular employee.
Hello, Mr. Vaidya, I think we lost your voice. Can you check your audio once?
Am I audible now?
Yeah, you're audible now. Sorry, please go ahead.
Right, sure. So as I was saying, we spoke about the proactive pieces and elements from a overall framework perspective. It is equally important where how to handle the conflict of interest from a whistleblower investigation standpoint. So unless the code of conduct, as I said, is very, very clear, you can't really define the scope and how you are going to treat the incoming conflict of interest in that particular parlance. Again, we not only need to look at the internal conflict of interest, but also areas beyond the internal company, like wherever there are touch points with respect to external third parties and vendors and customers. Even those has to be brought into the net to evaluate where the prejudicial interest is actually taken place. Otherwise, what you will be addressing is only the tip of the iceberg, and the larger issue, which is a process issue or that's a place where larger leakages would have taken place from a fraud perspective or exploitation by any third party, etc., will remain outside the ambit. Similarly, identifying any sort of disciplinary action. Again, we'll go into the details of this with Manishi. Speak
Mr. Vaidya,
from a legal perspective on that. Establishing a reporting mechanism.
Hello, Mr. Vaidya, can you hear me? You've lost your voice again.
As I said earlier, so the declaration, the signing off of code of conduct, etc., is again very, very key. Again,
Mr. Vaidya, can you hear me?
am I audible?
Yeah, no, I think for the last, if you can kindly repeat.
Yes, am I audible?
Yeah, now you're
Am
okay.
I audible?
Yeah, you're audible now. So if you can kindly repeat last 4 or 5 sentences, please. The last point. I think there's some.
Am I audible now?
Yeah, you're audible, but in between we lost your voice for
right,
a minute.
Absolutely. So I was just summarizing on having a. Okay, is it better now?
Yeah, it's better. Yeah, please.
Right. So I was just summarizing the point on redressal mechanism. At the same time, we need to have a proper redressal mechanism in place, which will have all the elements, how the inquiry is to be conducted in case of conflict of interest. What are elements not only within the company, but even externally touch points, whatever comes from a third party perspective, just rather than, touching upon a small issue, which will kind of end up just touching the tip of the iceberg. A holistic inquiry has to take place and proper disciplinary action in the reporting mechanism has to be, followed. So broadly, I thought I will, just summarize it more from a process perspective, how the redressal mechanism really works. And typical process and platform has to be provided to employees so that they should not come back and say, hello, there is no redressal mechanism, there is no declaration which was obtained, how do I report such things? And periodical checks and balances in terms of verifying those declarations and independently verifying ROC databases, etc. are there doing a sort of, it's very, very easy to, kind of go into the details of this. So in the interest of time, let me pause here and move over to Manishi.
Thanks, Yogen. I think you laid down a very, very intense background to this interesting and intense topic, I would say. But before that, thank you very much to WLA for giving me the opportunity. I have been given some pointers that I need to cover in terms of my presentation, starting with what is this law that is around the conflict of interest. For the people who want to defeat the purpose of the law, there is none. We need to start there. But so far, people who want to follow the law or who want to understand what are the complexities, what are the possibilities in terms of legal action that a company could initiate against an offender or an accused, there are ample provisions. And with the Companies Act having been amended and some of the statutes having been amended to include very broad definitions, I would start with saying that there are different provisions of law which do cover fraud kind of a situation. Let me start with, rather than making a distinction between what is applicable to private companies and what is applicable to public companies, listed or unlisted, let me just give a broad overview where we stand. Now, when I look at the conflict of interest, what we need to start with, first of all, is the Companies Act. Now, Companies Act has identified a specific definition of fraud under Section 447, and pursuant to which the SFIOs was given teeth to investigate matters and initiate prosecution against people who are non-compliant. Similarly, there is a duty that has been cast upon auditors that in case of violations, financial violations and all, there is an obligation on them to report it to the central government. If it goes beyond 10 million Indian rupees, approximately 150,000 US dollars. I could see some of the attendees from overseas. So looking at them, it's about 150,000 US dollars as an offense. So auditors have a responsibility to disclose whenever they get to know about certain violations having happened. Under the Companies Act, the central government has right to investigate the matters of a company upon notice or a special resolution having been passed by the company and having disclosed the nature of violations that they have faced or the fraud that has happened in the company. That is a right which is available. If we go a little further, the Section 184 of the Companies Act lays down obligation of disclosure by the directors on the nature of transaction or the interest that they may have in any company, which the company that they are a director of is interested or is going to do a certain business. And besides that, also stay away from participating in the matters where a common agreement or an agreement which is common between the two entities is being discussed. So that is just to give you a brief insight into what all Companies Act provide. Specifically, we have to pick up cases where conflict of interest situation may happen. There are about 20 sections which one can pull out. There is a direct or indirect reference to conflict of interest situation. And then non-compliance could lead into an action being initiated by the company against the people who are involved in this kind of a situation. If we go beyond Companies Act and we specifically look at the listed companies, there are requirements under listing and disclosure requirement that a listed company has to disclose, including the whistleblower requirement policies that they have to lay down. The LODR regulations do not specifically provide what needs to be in the whistleblower policy, but it's left to the best judgment of the company. But to have a whistleblower policy, that is an obligation. If you go beyond the listing requirement, the Prevention of Corruption Act definition was amended, and commercial organizations, which earlier we used to tell people that commercial organizations, the corporates are not really private or public companies are not covered by it, closely held or listed. With the definition of commercial organizations having been included in the Prevention of Corruption Act in 2019 or 2018, now even the persons who are officials of these organizations who are found to be involved in bribing or giving any undue favors to the government officials, appropriate action can also be initiated against them. And in case of a company, the company has to establish it bona fide that it was not aware of any wrongdoing by one of or more of or some or more of its employees, I would say. If we go beyond that, there is a provision under the IPC Act which talk about, there are two sections which deal with the dishonest misappropriation of funds and criminal breach of trust. So there are sections under the IPC which deal with these kind of scenarios. Prevention of Money Laundering Act also does talk about these kind of scenarios. So in terms of looking at what the law provides, there are enough provisions to nail a person who is involved in, I would say, illegal activities or who is actually involved in a serious conflict of interest. Now, we are typically talking about situations where there are apparent cases like an embezzlement or giving undue benefits to family members. But there could be several other instances where a situation for conflict of interest appears and it is not covered by any statute. Now, what do we do? And as rightly pointed out by Vivek in his last slide, it is most important for companies to lay down well-defined policies that deal with these kind of situations and what happens, what will amount to misconduct and what are the rights that the company has in case those instances come out to be as conflict of interest again involving an employee. Now, I believe Kulpreet is having some questions and he may ask those questions, but let me step back a little because I jumped into especially about what the legal rights a company has or what the provisions of laws are. I think the first and most important thing for us to examine, because we are discussing an issue which is not uncommon, or I would say, to put it differently, it's a very common issue across companies. People do not know where to draw a line. People do not understand where the conflict of interest situation may be. Companies may not be taking enough initiatives to propagate the message, what the conflict of interest means, what an employee is expected to do, what an employee is not expected to do. From my perspective, when I look at these kind of scenarios and companies' approaches on giving the advice on what companies should do, what kind of framework policy or companies should put together, my first and foremost question is that you first need to identify the root cause, where the problems may occur in your system. Because if you are a bank, then there is a possibility that certain employees, the chances of them getting involved in these kind of cases are higher than the others. So rather than just putting a policy in place and implementing it across board without paying due attention to what is needed to be done, first you need to identify where the maximum risk lies, and then identify where the minimum risk lies, and then put your policy accordingly. That is number one. Now, why the conflict of interest situation happens? When I would examine, and everybody has a choice to make a different opinion of it, there are two things which lead to a conflict of interest situation. One is a need, the other is a greed. I can't think of a third situation. We need to, as a company, we need to identify where the possibility of a need of an employee to create or get into a conflict of interest situation is, and where there is a possibility for greed and there is a possible conflict of interest that may happen. What the company needs to do, and I will pick a few from what Jugen said, but I believe there are 4 or 5 aspects that company needs to look at. One is, as I said, identify the areas of possible conflict of interest. Have a very nicely documented policy, and as Jugen rightly said, there are 3 aspects in a policy that you need to cover. Bring an awareness about the policy, because more than often it's been seen that companies put together very good policies, but when it comes to awareness, a lot of people have not even read the policy, or people are not aware. So I'm buttressing the point that having a policy in hand, bringing in awareness on an annual basis is another important aspect. Third is implement the policy. So when you come across a possible conflict of interest, take action. And last, what I say is propagate it well. When I mean propagation, it means reward the right and punish the wrong. And propagate this within the company, because that is where people get to understand. We all see, we humans are not born intelligent. We become intelligent over a period of time. The collective experience of each one of us makes us intelligent. And there are people who could lay examples for others. So people who understand the situation or circumstances well, which I mean the experts who are sitting in the market and who understand what kind of conflicts of interest cases are happening, they should be involved by the companies in understanding the issues rather than getting into a stage of investigation and then getting to know what the issues are. I would rather suggest do it firsthand. Rather than controlling the offense, try and ensure that you create a circumstance or environment where the offenses could be either eliminated or at least minimized. I would pause here and I will let Kulpreet or Yugen, if or any other attendees have questions, ask them. Kulpreet, you are on mute.
Okay, I'm sorry. Thank you, Mr. Pathak. So wonderful presentations. First by Mr. Vaidya, which is power-packed, informative, a lot of examples, and I'm sure lots and lots of takeaways for all of us and all our participants. And same goes with Mr. Pathak. So, Mr. Vaidya, can we go ahead now with the next discussion on the points that we had finalized?
Yes.
So I think, Kulpreet, in terms of most of it I covered, but let me just talk about the other 2 points that you had given to me.
Sure.
Addressing conflict of interest through investigation and sanctity thereof. So I would say there are 2 aspects which are important here. One is how thorough the investigation is, and what is how craftily you can use that investigation in initiating an action against an employee who has been involved, was found to be involved in a conflict of interest. So all that you have covered in your investigation without involving the employee concerned, you have to use it wisely against the person concerned, because unless the person has been party to that kind of a discussion, there is a possibility that all what you may have done, you may not be able to, company may not be able to use it to take an action against the employee. So it is most important to understand that when an investigation is being done, you are as a company, you are also examining parallelly the legal options that are available to you basis the investigation that is being done. And once the investigation has been completed, then what are the remedies or actions that you can initiate? So those are 2 important points that needs to be looked at: the amount or the depth or nature of investigation that you are doing, whether the employee against whom or group of people against whom an investigation is being initiated, are they party to it? Are they aware of it? Have they been interviewed? Then basis what you have figured, do you have a legal right to use it against those individuals? Or you can, what you have done may not really be helpful when you reach out to a lawyer and share the paperwork. Now, some of these aspects are relevant at a time when an employee is engaged with the company. There could be a situation where an investigation is ongoing, the concerned employee gets a whiff of it and resigns. The situation completely changes, because what you have done post his resignation, you can maybe rush to a court and try and take legal actions against him or her. But while he, if he's not in your employment, then situation becomes a little critical and difficult, because summoning a person to come, and depose before a committee or an investigator is not going to bring that person, because the person will outright refuse it. So it is very, very important to understand that what you have documented. I'm not giving because generally there's a tendency that you pick and choose and write what is said in a forum. What I would suggest that look at your processes very carefully, put documentation in a manner that you can hold the employee when an investigation is going on to the extent it is possible. And if the person has gone out, what are the rights that you have in your policy which you can initiate or implement even if a person has got a whiff and decides to leave the company? what all you can do post his exit from the company.
All right. Thank you. Mr. Vaidya, can I invite you now to please come in?
Yes, thank you. I think Manishi has covered all the parts typically, which we agreed in his opening statements and the follow-up part. So I think we are pretty much covered from the topic perspective, Gurpreet. So back to you.
Yeah, so thank you very much. So very informative discussion so far. We've got lots and lots of hellos from our participants and a few questions as well. They are not to anyone in particular, but I'm going to start with one by one. And Mr. Vaidya, you can take a call whether you will answer or you will invite Mr. Pathak to answer. The first one is from Gunjan. And she says, if a company restricts an employee by way of employment contract or relieving conditions from joining a competitor for 1 to 2 years after leaving, is this allowed and permissible under law?
Okay.
I would say it is a legal question, so maybe it will be pertinent if Manishi.
Yes, Mr. Manish, please.
Mostly, I think some of these aspects are beyond the conflict of interest as I would see them. We are looking at a restrictive covenant, the question pertains to. So post termination of employment, it is not enforceable in India that you can restrict an employee from not working elsewhere, including with the competitor. But yes, if you have signed documentation pertaining to confidential information, including the non-solicitation clauses, they are enforceable post-exit of an employee, even if the employee goes and joins a competitor.
But here, if I may say something, Mr. Pathak, as far as the government organizations are concerned, I'm confident about the central government. When a person either seeks a voluntary retirement or is removed from organization or superannuates, there is a kind of undertaking that the organization takes that for the next 2 years or 3 years or 5 years, whatever may be the case, the employee cannot share any information related to the organization or cannot even interact or join the organizations which are dealing with the parent organization. So, yeah.
That's absolutely correct, because that's where the sovereign interest is concerned. So being the government, these provisions can be enforced, but they have been challenged in certain circumstances.
All right. So just a further small extension. So if that's what the government is doing and can do, what is the status of the corporate organizations in this? Can this be done, or this is completely this provision does not exist in the law?
Contract Act is very clear that you cannot restrict an
Okay.
a negative covenant from an employee from joining a competitor, and this matter has been several times gone up to the Supreme Court, and they have upheld the provisions of law while enforcing the provisions of confidentiality and non-solicitation.
Okay, thank you. The next question is by Radhika, and this is on this. Can you please advise on how can one navigate through the perception of indirect influence that may prevail despite declaration of interest? I think we've covered this in many ways, but please, Mr. Vaidya.
Yes, I will answer that. So typically, like I mentioned in the redressal mechanism, so initiation of any such thing is declaration of interest, right? So that is the beginning, and that will go into the redressal mechanism where they will go into the facts and specifics of any particular matter. And if, let's say, in this particular case, if it is very, very material portfolio or whatever transactions being spoken about along with the counterparties, if it is very material and very relevant and strategically high, value, then clearly the organization can ask the employee to abstain from participating in the whole process as far as that particular declared entity is concerned. At the same time, I would also say, let's say if such transaction is non-material, not relevant, not very, very strategically important, I've seen organizations after such declaration of interest have allowed those employees to continue with their pursuit. So for example, investment in any entity which has nothing to do with the company's business, investment or any other sort of legacy business, whether it is real estate or any such matter like that, where it was declared at the time of joining and they were allowed to continue, and similar things. So wherever there are no immediate perceived sort of conflict with the existing business, people have been allowed to continue with those sort of pursuits. So that is how I would put it. So not necessarily it may be denied in all the cases. So depending on facts and circumstances of the case, the decision will be taken by the redressal committee.
All right, thank you. The next question is by Mr. Himanshu. And he says, hi, sir. The main reason for conflict is people who are top of the pyramid does not agree to listen what the employees at lower level are seeking. I really don't know what this means, but this is the question. So probably what Mr. Himanshu is trying to ask is that there is a communication gap about what basically makes the conflict of interest between the people who are higher up and the people who are down below. And because of this lack of communication, people are probably stepping into this territory called as conflict of interest.
Right. So I think that's a conflict of interest. Here, the conflict of interest we are looking at is primarily from relationship perspective with external agencies, and which impacts your ability to make the right decision in the interest of the organization we are talking about, not the internal conflicts, typically from a HR perspective or from employee, employer, or a superior or a subordinate level conflicts perspective. So I think it is a very different question.
Mr. Pathak, would you like to add something to this?
No, I think it seems to be a bit of a question with a grievance, so I would have avoided it. But I think it primarily boils down to how effective, first of all, what is the nature of entity that we are looking at? And secondly, what are the policies that the company has? Third, whether there are policies which, serious policies like whistleblower policies are in place, and whether people who are actually responsible for implementing the policies are serious about implementation. And that would be my take on the question.
Okay, thank you very much. I think these were the questions that we had. And time-wise, I think very disciplined. We've come more or less to the end of the session. Just 2 more minutes. And we will be sharing for the advantage of all the participants and others who might like to listen and benefit from today's discussion. We'll be sharing this on our website soon, and this can be caught once again there. But to conclude, I would like to say that now before I conclude, Mr. Vaidya, do you have any final points to make? And Mr. Pathak after that.
No, I'm good. Thank you.
Yeah, absolutely. I think this topic is of utmost importance, and unfortunately, it's not given that much importance in corporate world. Otherwise, the kind of matters which is coming up to me and Manishi both, it's tremendous. So I think a lot needs to be done in terms of training and awareness on this topic, both from a legal and also from a practical, corporate environment perspective.
Absolutely. I think you've nailed it, training and awareness, because many times people are not aware. And as you had said in your presentation that some of the employees during investigation, they say that I have indulged in this, but where is the company's loss? So there is a lack of awareness. And I think with time and talks like this, things should get better. Very exhaustive, very informative presentation and talk by both of you. I would like to thank for your participation and look forward to remain connected with you. Thank you.
Thank you, Kulbir, for the opportunity and pleasure interacting with all of you. Thank you.
Thank you very much. Thank you. Thank you, Mr. Pathak.